Hi everyone, my name is Jenna Runhell. I'm a senior associate attorney at Hayquist & Eck, and like many of you, I'm a full-time working parent whose child care was impacted by the COVID-19 pandemic. I have 2 kids, an almost 4-year-old boy named Santiago and a 7-month-old girl named Sophia. And in my situation, my son's preschool closed down back in March, and his typical summer school programs are not going to be open this summer. My kids were also watched by their grandparents who are over 65, and some are immune compromised, so they were no longer an option as well. And while it's been so much fun being home with them and getting to see them during the day when I usually don't get to, it has been a struggle to also work. And because the virus has not been contained, it looks like that struggle is going to continue likely through the end of the year. And so it's good to know for all of you who also have kids and are struggling trying to work that there may be an option for you to take a paid leave of absence. By now, many of you have probably heard of the Families First Coronavirus Act, which is a temporary federal law that Congress passed in response to the pandemic. It went into effect on April 1st and will remain in effect to the end of the year, and essentially requires all private employers and most public employers with less than 500 employees to provide paid sick leave and paid family leave for certain qualifying reasons. This includes for employees who need to care for their children because the child's school or place of care is closed, or their regular child care provider is no longer available for reasons related to the pandemic. Now, it's important to understand that eligibility under this child care qualifying reason is extremely broad, and chances are if your regular child care is not available for reasons related to the pandemic, you're going to qualify for leave under the FFCRA. For example, if your child's school is closed, but they're still receiving instruction online or virtually, you will still qualify. Place of care includes things like daycare centers, summer camps, after-school programs. And child care provider means anyone from a nanny or babysitter to a family member, friend, or if you're eligible under the child care qualifying reason, you're entitled to up to 80 hours of paid sick leave, paid at 2/3 your regular rate of pay and capped at a total of $2,000. Now, if your employer agrees, you can supplement that remaining 1/3 of pay with any accrued vacation, sick, or paid time off that you have, but your employer can't require that you exhaust this leave before providing you with the paid sick leave. And that's because under the FFCRA, the paid sick leave is in addition to any paid leave that you're already entitled to under your employer's policies or under. Paid sick leave under the FFCRA is available regardless of how long you've worked for the employer. Now, if you're eligible under the child care qualifying reason, you're also entitled to up to 10 weeks of paid family leave, paid at 2/3 your regular rate of pay and capped at $10,000 total, but you have to have worked for the employer for at least 30 days. And during those 10 weeks, your employer can require that you exhaust any paid vacation or paid time off that you've accrued under their policies. With the paid family leave, you can take it intermittently, meaning you don't have to take it in a full 10-week chunk. You can take it as you need it. So if, for example, your child usually went to school Monday, Wednesday, Friday, and their school is closed, and therefore you only need childcare on those days, you can use the paid family leave on those days only so long as your employer agrees to it. Now, to request paid sick leave or paid family leave under the FFCRA, you'll have to provide your employer with certain information. This includes your name, the dates that you're requesting leave, the reason for your leave, and in this situation it would be the child care qualifying reason, and a statement that you're not able to work because of this, the name of your child, the name of the school or place of care or child care provider who is unavailable due to COVID-related reasons, and then a statement that there's no other suitable person available to watch your child. So what this means is that typically a co-parent or co-guardian is not going to be able to take paid family leave or paid sick leave for the same childcare qualifying reason at the same time as you. Because if you're both taking leave at the same time for this reason, then arguably at least one of you is available to watch your child. You have the right to return to your job or to an equivalent job after you take leave under the FFCRA. And your employer is prohibited from firing, disciplining, or otherwise discriminating against you for either requesting the leave or for taking the leave. That said, you're not protected from employment actions that would have happened regardless of whether or not you took leave. So this includes if your employer has to do layoffs while you're out on leave. For more information about your rights under the FFCRA or about your employment rights in general, check us out on the web. Our website is www.haelaw.com.